on to my risk reduction tips. I want to try and keep you guys out of jail. And of course, most of you that are here probably won't wind up in jail anyway because you're conscientious enough to be here. So I want to just get started. A lot of these are common sense things, but you'd be surprised how many of those wind up in lawsuits. First of all, if you receive an attorney general inquiry, respond to it, please. Believe it or not, a lot of folks think, oh, this is so frivolous, I don't even need to respond. And the Attorney General's office has told me, don't let them ignore those inquiries because we can't dismiss it unless they respond to it, okay? So if you receive something, please don't dismiss it as frivolous, answer all complaints. That way you can get rid of it a lot quicker and easier, okay? Keep a good file. I'm sure you're told this every day in your office. You know, document, document, document. Diary all your deadlines. If you miss a deadline, you're going to get sued. It's hard to do, I know, and it's not always easy to stay on the top of those deadlines, but you have to do it. It's also good to combat selective memory on behalf of your clients. If you don't document something, if you tell them, oh, you know, I said to get an inspection and they didn't want to get an inspection. You need to get that in writing and document that, and then you have evidence to rebut a claim if they come back later and say you weren't doing your job, okay? And make sure all the forms are completed as well. Number 3, don't fill out the seller disclosure form. That's for the seller to do, okay? The seller has to do this. That is not your responsibility. You can check it for completeness, but that's about it. I have a case, a Supreme Court case that recently came out on the seller's disclosure form, and I'll talk about that at the end of this list. Number 4, insist your client have an inspection. I hope none of you let your clients buy a property without having an inspection done. If you do, if they absolutely say, no, can't afford it, don't care, don't want it, make sure you get your recommendation and their waiver in writing to show that you did recommend that they get an inspection. We know you can't always control your clients, but at least have in writing that you did make that recommendation, because you'll be the first one to get sued if something's wrong with that property and they waive the inspection. That seller disclosure is not meant to replace an inspection. Number 5, don't hesitate to fire the problem client. And you know who these people are, right? You can tell as soon as they walk in your door. It's hard sometimes because you don't want to, you know, turn away business, but it's worth it. You just listen to that radar that you have inside of you, and try not to get involved with someone that looks like a train wreck. Okay. Number 6, don't give legal advice. I know none of you do this. That is called the unauthorized practice of law, and it is a criminal offense. You guys really get to tread pretty closely into the legal arena because you're filling out contracts, and your clients are constantly wanting to ask you, is this a valid contract? What are my damages? What would be my legal remedies? You know, you have to be able to tell them, you know, I can't answer that. You need to talk to an attorney. Okay. Number 7, be vigilant about earnest money. Earnest money is always a big, big issue. Okay? You need to deposit that earnest money in a trust account in a timely fashion. There was just a recent suspension of someone's license because he had overdrawn this account multiple times. So, you know, they are out there watching. You need to be very careful. You also, I know there's always issues with, well, when do I need to receive the earnest money? Or when do I need to get that earnest money? In today's world, it's changed a little bit. You know, some earnest money used to be always with the offer. It's not always with the offer. But what the license law says is that has to be deposited within 2 banking days after acceptance of an offer. So you need to make sure, as the buyer's agent, that listing agent has that check to be able to deposit that within 2 banking days after the offer is accepted. Otherwise, that seller can terminate that agreement. You don't want to get into that situation where the buyer then turns around and sues you because you didn't get that check to the seller in time, okay, or to the listing agent. Number 8, red flags of mortgage fraud. Everything has to be on the HUD one. no money under the table, carrybacks that are then forgiven, a big red flag, okay? Don't get involved in any type of mortgage fraud. If it doesn't smell right, don't do it. We've had people that have actually had to back away and not attend a closing where they felt like something funny was going on. Number 9, don't violate foreclosure consultant laws. There's a foreclosure consultant law in Indiana that requires you to be registered with the state if you're consulting regarding foreclosures. It also requires a bond be registered and registered with the state. I believe it's a $25,000 bond if you are a foreclosure consultant. Well, you guys are not foreclosure consultants. You list and sell homes that may be going into foreclosure, but you shouldn't be considered a quote foreclosure consultant and have to, satisfy all those other requirements. But the Attorney General's office is out there looking for people that are advertising stop foreclosure and not that, with no sign that you're listing or selling homes. So it doesn't really look like you're a realtor. It looks as if you are a foreclosure consultant. So you may get an inquiry from the Attorney General's office if you're using words like stop foreclosure. Okay? Just wanted to make sure you were aware of that. You're not supposed to be doing loan modifications. I know short sales get kind of dicey, and some of you have accreditations with short sales, and that's fine. But there was a big billboard out west somewhere that had a big stop sign and the words stop foreclosure, and the Attorney General's office felt that was treading over the line there. So hopefully none of you are doing that. Last, I have recent legal cases for risk reduction. That's actually not a tip. I guess the tip is to know the case law, which on the next page is the Supreme Court case that I was talking about that just came out in June of this year. This is a pretty big deal to have a Supreme Court case discussing this area. We don't usually get this. We're lucky to get Court of Appeals decisions that affect us in this area. But the Supreme Court affirmed in recent appellate court decisions that a homeowner cannot lie with impunity on a seller disclosure form, even when a home inspection has been performed. I know that seems very common sense, doesn't it? Well, of course you can't lie. Believe it or not, before this case though, if a home inspection had been done, a buyer was out of luck to try to sue the seller for any kind of inaccuracy on that seller's disclosure form. So this case now makes it the way it should be. If you lie on that form, you can be sued for misrepresentation. Actual knowledge is required by the seller though, at the time that disclosure is filled out. Should have known won't be enough for liability. Okay? So it does require actual knowledge. The court said that the seller's disclosure is not a warranty and it's not a part of the purchase agreement. Okay. So it was good language by the court, very good decision, and hopefully sellers will be a little more cautious when they fill out that seller's disclosure form now that they know that they can be liable if they don't tell the truth. Further risk reduction tips. Avoid practicing dual agency or limited agency. Problem is when something goes wrong, they're going to look to you. They're going to say, you were representing both of us, you weren't being fair, you weren't exercising your fiduciary duties. It's a very, very risky area. Also, representing yourself in a real estate transaction is a very, very risky area. I'm not telling you you can't do limited agency or that you can't represent yourself. I'm just saying exercise caution, be very, very careful, try to get everything in writing, make sure, especially if you're representing yourself, that you are not somehow acting as an agent for that other party. Because sometimes a court will impose that agency relationship if you have a superior knowledge, which you all do. Okay. Know your limitations. Be comfortable with your uncertainty. Be comfortable that you don't know the answer. It's hard to do because you want to act like you always know what you're talking about. But if you don't know, just say so and then tell them, you will send them to a qualified authority or someone that can give you the answer. Do not misrepresent. This is a big, big liability issue. Don't speak carelessly. Just as I indicated, a licensee has to exercise a higher degree of skill and diligence than a non-professional. A broker or licensee is going to be charged with more than the layman's knowledge of that real estate business.